bargaining, the evolution and development by Dr. Vijayalakshmi, an assistant professor of SOEL, Tamil Nadu, Dr. Ambedkar Law University, down Chennai. And as we all know that plea bargaining is a concept which took place on the reports of the 154th Pay Commission, 54th Commission report, Law Commission report, which recommended that there should be a concept of plea bargaining, just like what is available abroad. And taking into consideration the recommendations, they were accepted to the effect that in certain offenses, except for economic offense, where you could bargain with the prosecution to the effect that I concede to the guilt, but in lieu thereof, as the word itself shows that there is a plea for bargaining. And if the bargain is accepted to the parties, then yes, on the basis of that, there's a lot of evolution. This concept of plea bargaining was, as earlier said, quite popular down in foreign countries. And it was a huge success, though the critic says that in a criminal jurisprudence, the concept of plea bargaining shouldn't have been brought in. It has its own facets, but as we have seen, it is evolving and evolving for the betterment of the society. Like we all do, even the judgment says, keeping in view the consideration of Section 321, where it can be compounded. So, where if it is in the larger, I can say it's not akin to mediation, but it is like a win-win situation. The courts are already clogged with the litigation. The litigation comes to an end. The prosecution is happy. The person who gets bargained, who due to some flux of the momentary heat of moment, etc., gets into the wheels of criminal jurisprudence set into motion. He bargains in that. So at least I can say that plea bargaining is a concept to stay, and it is evolving with the flux of time. Taking into consideration that this would be a good session for the purposes of students of law, advocates, those who are preparing for the judicial exams. For such type of webinars, we have always been connecting with Legal Elite Group, and it is always pleasure connecting with their main host, the main anchor sheet. As they say down in the newspaper, what bottom line of the article says, it's an anchor sheet. So I can say that connecting down south, the anchor sheet for us is Vijayalakshmi Logamuthi. And it's always pleasure connecting with her, and when, especially on the platform where knowledge is being shared. Over to you, Vijayalakshmi ma'am.
Thank you so much, Vikas. It is always a pleasure connecting with Beyond Law CLC. Vikas and his team is doing a tremendous job in knowledge sharing, and not only the legal issues that is being dealt with, or the laws that are being dealt with, anything connected to the profession. Certain sessions are very, very good. I recommend for all his sessions, all the law students and the lawyers here. And today Vikas is a well-known personality down south, and this connect we welcome. And today's faculty, Professor Dr. Vijayalakshmi, is very well known to me. She was practicing law for around 7 to 8 years in the court before joining an academic pursuit and taking it forward. And she is a very good academician because of her knowledge as a practicing lawyer and academic thing, both hand in glove it goes in. That's why her sessions are very good. It is useful for the students, as Vikas told, for any law student, but for me, every lawyer is a student till the last breath. So anyone connected with the legal fraternity, this is a very good session. On behalf of Beyond Law CLC and the Legal Elite, the Academy of Law, we extend a warm welcome to all the participants, and on your behalf, we extend a warm welcome to today's guest faculty, Professor Dr. Vijayalakshmi. Madam, the floor is all yours. Before that, I request Vikas to invite her.
Yeah, over to you, ma'am, and we have allowed the screen sharing to you.
Thank you. Thank you so much, sir. Again, I want to register my gratitude and thanks to both of you, Madam Vijayalakshmi and Sir Vikas, sir, for your, again, giving me one more time to come into this platform and sharing my views on the another topic. Really, it's a privilege. It is not something which is coming from the mouth. It's from the bottom of my heart, and it is a privilege to be in one among the platform. And thank you once again. Now, let us start to the slides. Okay. So, as said by Sir, the concept of plea bargaining, and before getting into the actual concept of plea bargaining, it is not something which is again equivalent to, or which is something more or less equivalent to compounding of offences. There is a difference between compounding of offences and plea bargaining. The foremost thing why I choose this topic, or the foremost thing, what is the importance, what are the nuances of this plea bargaining is that after a long time, after several decades, the criminal justice system provides some space to the victims. So here plea bargaining, which gives the more importance to the victims than the accused and to the prosecuting agency. Because usually victim will not be in figure, victim will not come in any of the scene throughout the justice system, either in the course of trial or in the course of investigation. Nowhere the victim will come. So everything either by the police or by the prosecution, they will decide, or the court will decide what the justice should be given according to the law which is written in black and white in the books. So does anyone at any stage, whether we thought that whether this is the actual justice the victim is expecting, whether the victim is going to be satisfied with that of the punishment what we are going to provide or what we are going to sanction to the accused is a question here. So there are several times as we are following the reformatory theory of punishment, again solely we are thinking about only the accused perspective, offenders' rights, convict prisoners' rights, or arrested person's rights. So do we think about what are the rights of the victim? Where we think about the what is the space for the victim provided in the justice system? So in 2005 only we came to define who is a victim. Before that even we don't have the victim also, the definition for the victim also. So the first time victim has been defined in the International Convention, and we borrowed that, and in 2005 we got the definition in the CRPC. So it simply says whoever being the victim of physical or psychological or monetary loss. So this was the definition given by them. So in such a case, I thought that it's my personal opinion that plea bargaining is one of the finest concept which fulfill the victimological perspective, where the victim can justify, where the victim can decide what he wants. So that is the concept behind this plea bargaining. And as said by Sir Vikas sir, it is not a concept comes from the originated from India. It was a concept which has been borrowed from US, which was very successfully practiced in US. We borrowed this concept from US constituency, from the US criminal justice system. So plea bargaining, though we are not practicing plea bargaining after independence or in the Indian Penal Code or the Code of Criminal Procedure, even during the ancient time, we practiced this victimology or plea bargaining by way of exchange matters. So whoever commits any offense, let the victim decide the punishment and let the victim imposes the punishment. That we have some traces when we have some the epics and Vedas we could see. But after the codification of criminal law in India, there was no concept by name called victim plea bargaining. So it was purely dependent upon the criminological or more purely based on the accused perspective. So plea bargaining, which comes into effect from 2006, it had a long pending backwork, preparatory works done by the Law Commission of India, as said by the 142nd Law Commission report, having a very big impact over the outcome of this plea bargaining. So simply what do you mean by plea bargaining? Whether it gives the rights to the accused to bargain his charge, to bargain his sentence. So what is the role? What are the legal procedures involved in it? What is the scope of involvement of victims into it? All these things come together in plea bargaining. It was been comes from section 265A to 265L of the Code of Criminal Procedure. So now we are going to conduct, have the session in two phase. First phase, we will discuss about the origin, the developmental procedure of plea bargaining comparatively with the US. And then we come to the actual provisions, what we are following in India. But unfortunately, though it has been coming to effect in the year 2006, how many cases, how many petitions has been filed for plea bargaining is the question again. How many of them or how many of the legal practitioner has started to practice this concept is a question, because when the Law Commission started to work on this plea bargaining, there was a huge opposition was from both prosecution side and the defendant side regarding this pre-bargaining. So more particularly, the defendant doesn't want to practice this because it may affect their profession also. But in spite of that, as we are working at the end of the day for the victim justice, we have to encourage and we have to create an awareness regarding this concept. So plea bargaining, according to the English law or according to the US law, it is nothing but it is a negotiation between the prosecution and the accused in pre-trial stage. So this was the understanding given by the US Constitution, US criminal justice system. It was not the definition under the 265A to L of the CRPC. So what they stated is a negotiation between the prosecution and the accused in pre-trial, before the commencement of trial. And if the accused agreed to plead guilty in exchange for certain concession. So here certain concession is not of monetary sanction or coming out of the clutches of law. It is in getting of some lesser punishment. Lesser punishment means not below the prescribed minimum punishment, lesser punishment. For example, if the prescribed minimum punishment is 3 years, he may get 3 years. But if the trial would have been conducted in a full-fledged manner, if there is a possibility of getting the maximum sentence of 7 years, so here the concession what he is getting is 3 years. So this is the thing. It is a give and take policy which been practiced in US. So the concept of plea bargaining, as I told you, it is the thing we borrowed from the United States. It comes in that. So let us check it out. What are the background work of this plea bargaining and how come the Law Commission has given their input regarding this plea bargaining. So the 142nd Law Commission report is exclusively speaks about this plea bargaining. So they have underwent a tremendous research over it. They conducted several research. They conducted several samples, questionnaire. They underwent. They have dissected the entire criminal justice system of the US to find out the advantages and disadvantages. What are all the objections raised in US when they want to get the constitutional validity of this plea bargaining? Everything has been comes within that. And why they choose this concept to be implemented is a question. So why the 142nd Law Commission has choose this plea bargaining to be introduced is that, again, as said by sir, it was a problem of delay in disposing of a trial, overcrowding in prison, long time pending of cases, logging of cases in all the courts, right from the magistrate level till the district magistrate court level or the sessions court level. And they included the appeal and revision cases are pending before the high courts and supreme courts also. So the major problem is that overcrowding and long pending of cases, and the presumption of innocence lost its value. So unless otherwise the trial has been disposed of speedy manner, unless otherwise the trial has been disposed of by conducting the trial in full-fledged manner, where is the question of enjoying the concession of presumption of innocence? So presumption of innocence is still in question stage unless the trial has been completed. And the suspected person is simply
I think she's re-logging in because of the. She had said that the poor network is there out there. We're just cross-checking it out.
Vikas?
Yes, ma'am.
Whether it cut in
she
between?
Has got connected.
Pardon?
She's got connected. I think ma'am
Yeah,
is
she has got connected.
Yes.
That's why you have written strong people are simply born. They are made by the storm they walk through. So she has walked through.
Yes, thank you.
Okay,
whether this slide has covered, sir? Whether I have to continue the slide?
Which one? There's no slide right now.
I'm sharing. Okay, just a minute.
How the slide hidden?
Whether this slide has covered?
It hasn't popped up. You're talking about this. You were talking about.
Okay. So this is all the reason why the Law Commission has decided to go for the reformation in the criminal justice system with respect to this plea bargaining. Why they want to include plea bargaining in the CRPC. So first and foremost thing is, as said by sir, it is overcrowding in prison and long pending of cases. So problem of delay in disposing of the trial. So they gave example and they submitted the cases to show how long the cases has been pending. For example, the Law Commission has conducted the research in the year 1991. In the year 1991, they came to know that it was pending even from 1970, 1950s. So, for how long time the trial is being pending, or how long time the appeal or revision is pending before the High Court. So, because of this reason, it has been reflected in the overcrowding prison problem. So, the person are languishing in prison when we are following the golden principle of presumption of innocence. So where is the question of putting a person behind the bar simply because of the under trial prisoner or the remand prisoner because of delay in conducting the trial or delay in conducting the investigation. So where is the question of appreciating the presumption of innocence over there? And they followed the principles which has been successfully followed in the US. They picked up this concept has to be included in the Indian justice system also. So there are several grievances regarding this disposal of criminal cases before the Judicial Magistrate Court, Sessions Court and District Court. There are several bills also filed. For example, Madam Sheila Barsai has filed a bill before the Supreme Court questioning the quality of the prison inside, the sanitation and the quality, the protection for the women and the children inside the prison. So these are all the things which has been discussed in this Law Commission. And some cases exceeds the limitation. As I told you, in a CRPC, it imposes the limitation for concluding the trial. So when we used to do limitation act for filing in controlling the delay of filing appeal or revision or petition, but CRPC imposes limitation to conclude the trial also. For example, if the case is punishable up to 6 months, the trial has to be finished within 3 months. If it is more than 6 months to 1 year, it has to be completed within 6 months. If it is more than 2 years, within 1 year, it has to be completed. So there are some cases where their under trial period exceeds the maximum period of imprisonment if it have been found guilty against him. So another condition is they are languishing in prison in an inhuman condition along with a hardcore criminal. So prison, it is not as they are not the convicted prisoner, they are being kept along with the under trial prisoner. So the overcrowding of prison is one problem. And mingling of the person who is committed a simple crime or a smaller crime is coming in contact with the person, those who have committed a graver crime. So that also being one of the reasons why it has been exchanging of their experience, and how once a person comes inside the prison for committing a theft, he will go out with an idea how to commit a robbery or dacoity or murder. So these are all the problems involved in it. So as I said, with respect to this appeal and revision, the Law Commission has quoted that there are several cases pending before the High Court and Supreme Court for more than 5 to 6 years for simply the appeal. from the date of admission. And in the year 1991, as I told you, some appeal are pending from the year 1979 onwards. So from 79, 89, 99, 91. So for several decades, appeals are pending. So for quoting all these reasons, the Supreme Court has expressed their views in several cases. So what is the any other mode or via media to come out of this evil? Delay in disposing of the cases, overcrowding in prison. And in Husainara Khatun case, again, the Supreme Court has expressed the view that alarmingly large number of men and women and children are behind the bars for years expecting trial in the court of law. So, either it may be Khatri versus state of Orissa, or Sheila Barsay versus Union of India, or Husainara Khatun versus state of Bihar. So the public interest litigation cases or any writ cases filed before the Supreme Court questioning the speedy disposal. So they are expecting, even the Supreme Court is expecting some mechanism to control this, to cut down the unnecessary delay which has been on the part of the judiciary and as well as the prosecution side. So at the time, the Law Commission has been entrusted with the task to ascertain what is the mechanism to be implemented to prevent this overcrowding in prison and to prevent this unwanted delay in disposing of the cases. So with this respect, the Law Commission has conducted this, and they have conducted the survey in several states. Another thing. So here, the Supreme Court questioned, because the Law Commission has quoted all these remarks in their report. The Supreme Court questioned if there is an unnecessary and undue delay in deciding the cases, so how could we put forth the faith of judiciary among the person? So when we are stating that when a person who is due to poverty or indigenously or not having any proper background, so why he should be not affordable to come out of bail, is languishing in prison. So it gives the concern that after independence, after the codification, that the status of this person has not improved. So that's what the Law Commission has conducted this thing. And when they're conducting the survey, when they're conducting the research, the Law Commission and its members expressed their views that some state government are not cooperated with them. And they were very reluctant in providing the data regarding the undertrial prisoners or the person, those who are languishing in prison, how many cases are pending without delay. So these are all the flaws that has been faced by the Law Commission when they are conducted this research. And let us check into the actual view, how the plea bargaining has been practiced or practicing successfully in United States. So this is a pure concept which has been practiced successfully in US, and it has been entrusted or it has been reflected in the Law Commission report itself. It says that we borrowed the concept from the US. So it says that, but the practice is something different from India. What we are practicing in India as a plea bargaining is not the practice which is being practiced in US. Because in US, the plea bargaining has been falls into two distinct categories. One is charge bargaining and another one is sentence bargaining. And this either the charge bargaining or sentence bargaining, it depends upon the prosecutorial concession. So the entire plea bargaining concept has been under the control of the prosecution, which is not the same in India. So here prosecution has no role in deciding the plea bargaining, but it is the highest role playing in the US justice system. So charge bargaining in the sense, the prosecutor gives promise in the sense, once the accused come forward to plead guilty, then the prosecutor may reduce or dismiss some charges. What we are following in discharge and other concept. So it depends. This is the charge bargaining. So charge bargaining comes before the commencement of trial, which is equivalent to discharge. But in discharge, we are not entering into a bargaining with the accused person. It will be done only by the presiding officer or the trial judge. When there is no prima facie exist, the charge will be discharged. The person will be discharged from the particular charge for non-existence of prima facie. But in US, in a concept of plea bargaining, charge bargaining is before the commencement of the trial, if the accused person pleaded guilty, he will be either the charge will be reduced or he will be discharged. The next one is sentence bargaining. So what do you mean by this sentence bargaining is promise by the prosecutor to recommend a specific sentence. So here it will come under section 313 or after the prosecution side or during the course of judgment. So even then the prosecution has no power to decide the sentence. But here in sentence bargaining, the prosecutor is having power to either recommend some sort of sentence that can be imposed on the accused. So through this sentence bargaining, if the accused person pleaded guilty, either he may recommend for specific sentence or he may refrain from recommending the sentence. So this is it. And as I told you, this provision is not available in India. Till now, there was no such a provision which gives powers to the prosecution to decide what to be given and what not to be given. So whether this plea bargaining, is there any traces of plea bargaining before 2006 or 2005 is that? There was no any traces of plea bargaining before 2005 or 2006, but it speaks about some provision which speaks about pleading guilty of some petty offences. Even now pleading guilty is there, but pleading guilty is not equivalent to plea bargaining. So plea bargaining is something where it is going to give some remedy to the victim also. In pleading guilty, the victim is not going to get any remedy. It is only applicable to the accused. So entering into pleading guilty or guilty plea is very prevalent in American states. So that's what they favored. So in most of the cases, even the case entered into the court, most of the accused person are very well ready to plead guilty and they are ready to pay the fine and they want to come out of the come out of the punishment. So when before taking into legal perspective regarding this plea bargaining, when the US conducted the survey, the reasons that has been recorded for favoring the plea bargaining, why the American citizen are favoring plea bargaining is, so they states that anyhow most of the person are going to accept the charge immediately after arrest. So to avoid unnecessary trial procedure, this plea bargaining is one of the finest concept. Either it may be charge bargaining to come out to complete the case, and it will avoid wasting of public money in conducting investigation, in conducting trial, in imposing punishment and sending the person to prison at the cost of the state. And it is a compromise, and it is a give and take policy. So plea bargaining is a compromise. Compromise with whom? Compromise with the victim. So once we come into the exact provision, I will show you how it is a compromise between the victim and the accused. So both the side is going to enjoy the benefit. The accused and as well as the victim are going to enjoy the benefit. And time consumption would be prevented. So under trial, long delay of pending of disposal of cases, delay in conducting of investigation, all these things could have been prevented. And the defendant will get concession in sentence, though the evidence are against him. So if the trial would have been conducted in a full-fledged manner, in a full trial, if there is a possibility of imposing maximum punishment through plea bargaining, the accused might have get lesser punishment. So these are all the favoring circumstances which are given by the citizens of US for getting this plea bargaining into their law. So the law commission, the members of the law commission also accepted this, and they quoted some landmark judgments of the US who reinstate that why plea bargaining is most important. So in two important cases, the US Supreme Court has stressed their view why they need this plea bargaining. So they say that the first view expressed by the US Supreme Court is that innocent will not plead guilty. So the person who has not committed the offense will not come and accept the charge. He wants to face the trial, and he will try to prove his innocence. So on that belief, they feel that the person who has committed the offense only come for the pleading guilty or plea bargaining. so it will not affect the rights of the innocent person. And the accused wants to save money, time, and he decided to have a new life once he come out of the sanctioned imprisonment, sanctioned punishment, because the punishment is going to be anyhow a minimum punishment or lesser punishment. So he wants to start a new life by way of availing this plea bargaining. And the Supreme Court has upheld the constitutional validity of plea bargaining and recognized the value of plea bargaining also. So it was very strict. The US Supreme Court was very strict with respect to recognizing the plea bargaining by stating that unless and otherwise the plea bargaining has been submitted voluntarily, by deliberately and informed and understood by the accused person, then only it will be an accepted plea bargaining. So it again and again state that there should not be any informal plea, acceptance of plea charges, or there should not be acceptance on the basis of false promise or coercion or threaten anything. So it must be comes out of voluntarily, and it has to be deliberated, and it has to be informed and consented by the accused person. And they accepted that plea bargaining is more than an admission. It is not equal to confession. It is more than an admission. So it shall not be utilized in future against this person. And they want to give an undertaking from the accused person by stating that he is willing to waive the right of full trial. Because once they are going for either charge bargaining or sentence bargaining, what it states, they don't want to go for the full trial. They are accepting the charges. They are ready to receive the punishment. So it is one of the procedure over there that they should come and give the undertaking. They are waiving their rights. So the plea bargaining provides advantages to the defendant and as well as to the state. So here the US law is purely depends upon only the state, prosecution and the state. The victim has no direct role in plea bargaining, which is totally opposite our concept. So they also state that pleading guilty or plea bargaining is also enhancing the quality measures of rehabilitative approaches. So the accused will not commit the offense once again. So after sometimes the Law Commission has compared the work of Canadian Law Commission also with respect to plea bargaining. But there was not any strong impact of Canadian Law Commission's report with respect to plea bargaining. But to give the more substantiveness to the plea bargaining, Law Commission of India has quoted the work of Canadian role also. So before coming to this plea bargaining, before the plea bargaining coming into effect with the Indian Penal Code, for the Code of Criminal Procedure, in the year 1979 and 1980, there was a traces in two cases where they speak about plea bargaining. So though it is not a direct case which concerned or deal with the plea bargaining, but the justice has referred the concept of plea bargaining in the decision. So one is Muralidhar Meghraj Loya was the state of Maharashtra, and another one is Kasambai Abdul Rahman Bhai Sheikh was the state of Gujarat. So in Loya case, it was by Justice Krishnaiah and Justice Goswami, and in Kasambai case, it was by Justice Bhagwati and Justice Singh. Instead of this Kasambai's case, Muralidhar Meghraj Loya case has a very big impact regarding this plea bargaining, what we are following now. Why in the sense, in Meghraj Loya case, it was a case of an food adulteration. In the trial court, he pleaded guilty, that is, he entered into the plea bargaining, and the trial court awarded him lesser punishment, which is very less than the minimum prescribed punishment. For example, for the food adulteration, the minimum punishment is 2 years, but the trial court awarded 3 months of imprisonment. So the state went on appeal against the sentence imposed by the trial court for the enhancement of punishment. The High Court has enhanced the punishment from 3 months to 2 years of imprisonment. Against that order, the appellant, the accused in the trial court, has preferred an appeal before the Supreme Court, challenging the enhanced punishment. So at the time, Justice Krishnaiah has discussed various factors, which includes the plea bargaining also. And he stated that the guilty plea or plea bargaining entered into by lawyer was under the informal inducement on light sentence. It is not to be accepted as a valid pleading guilty. They refused to reverse the judgment passed by the High Court by stating that the offence involved in this case is food adulteration, which is the violation of social justice and societal health and hazardous. The trial court erred in sanctioning lesser sentence than the prescribed minimum sentence. And more importantly, they state that no legal authority for invoking plea bargaining, which is not recognized by the Indian criminal justice system. In the year 1979, though there was no concept of plea bargaining, though we never heard about the concept of plea bargaining, Justice Krishna here has mentioned this in his judgment when they are upholding the judgment passed by the High Court. And what are the objections raised by the various stakeholders when the Law Commission recommended for this plea bargaining? So once the Law Commission has started the work, we know that recently Verma Commission, when they worked out for the amendment of criminal law in India, after this Nirbhaya's incident, they asked for the public view. We ourselves also has recommended several views to the Verma Commission. There was a for and against that sentence, like that. So like that, when the Law Commission asked for the public opinion for the implementation or introduction of this plea bargaining, the objections raised from the several stakeholders, from the prosecution side, from the defense counsel side, from the social activists. So what they feel that it is the social justice shall not justify. Once plea bargaining comes into effect, it will affect the social justice and it will result in conviction on the innocence, because they don't want to face the trial, so they will be coming also to come out of the thing, they will accept the plea bargaining. And poor will be the ultimate victim, where the person, those who are indigenous or poor, who is not afford to pay as a compensation, they will not afford to this, they will become the victim. Counsels appearing for the accused opposes confession invoking procedure, because in plea bargaining petition, the person has to accept the charge, which is not equivalent to confession, but which is equivalent to admission. And the prosecution side state that plea bargaining will increase incidence of crime. So it is a process that where I can commit a crime and I can go and ask for plea bargaining and will pay the money and will come out of the law. So this was also one of the query raised by one of the objections submitted by the public. And more particularly, they state that no social benefit accrues. So what a society is going to get out of this? So the Law Commission has come up with an idea and the suggestions how to overcome this. And they state that application of plea bargaining with a limitation. So plea bargaining shall not going to be an absolute concept. It must be a conditional one, because as advisor, there are some limitations where plea bargaining shall not be applicable. And they want to establish a competent authority to discuss about this plea bargaining related petitions and lay down the procedure. There must be a strict procedure should be laid down under the procedural aspect to deal with this plea bargaining. And more particularly, the accused must be informed regarding the pros and cons of this plea bargaining. So with all these, the Law Commission has come up with this. So after they submitted the report in the year 1991, after several, and in the year, then the next Law Commission, 154th Law Commission, and in the year 2005, it got the assent and it came into effect in the year 2006. So even in 2003 Malimat Committee, which is meant for the police reformation and the criminal reformation, it also recommended plea bargaining as an amicable solution for quick disposal of criminal trial and pending. Again, it has been reinstated by them. And the Malimat Committee stated that the recommendation of this 142nd and 154th Law Commission may be incorporated, which is one of the finest and wonderful mechanism to avoid the long pending of cases. And the Law Commission has examined the position to dispose the cases without trial by way of compounding or plea bargaining or by way of settlement. So compounding of offences, we should not treat parallelly with plea bargaining. Compounding offenses is something different, which is not in consonant with the plea bargaining. So plea bargaining starts from section 265A. It speaks about submitting of an application for plea bargaining. So, a report submitted by either the police officer in charge of the police station under section 173 CRPC. So, once the 173 CRPC speaks about submitting of the final report, which means the charge sheet. Once the investigation has been completed, once the police has submitted the charge sheet or the final report, and if it is an offense which is not punishable more than 7 years. So the first restriction which is imposed to avail plea bargaining is the offense should not be punishable more than 7 years. Offenses punishable within 7 years are eligible to avail this plea bargaining. And complaint taken into cognizance by the judicial magistrate and witnesses were examined. So the first two stages are for the complaint under section 2D of CRPC. The third situation, circumstances for the complaint preferred before the magistrate court under section 200 CRPC by way of private complaint. If it is by way of private complaint, once I submit a private complaint, the state should be taking cognizance and examination of witnesses. And 265A speaks about continuity. For what are all the offences, this plea bargaining shall not be applicable. Very strict interpretation. Plea bargaining, though it is within 7 years of imprisonment, shall not be applicable to whom, and whom is that? For first of all, offences affecting the socio-economic condition of the country. So, as I told you, this food adulteration, now we have FSSAI Act. So then, like this, what are the offences affecting the socio-economic condition? For that offences, no plea bargaining. And offences against the women and children below the age of 14 years, there will not be plea bargaining. Other than that, in the year 2009, the central government has included several laws which are not eligible to claim plea bargaining, like Dowry Prohibition Act, Commission of Sati Prevention Act, Indecent Representation of Women's Act, Immoral Traffic Prevention Act, Domestic Violence Act, Child Rights Act, Juvenile Justice Act, Army, Navy and Air Force Act, Explosive Act, Cinematograph Act, SCST Prevention of Atrocities Act, Food Adulteration Act. So the list has been laid down by the central government itself. For these cases or the cases relating to these act, there shall not be plea bargaining, though it is an offence punishable below 7 years. So that is one of the restrictions imposed by the central government. And application. So what do you mean? How to file an application for plea bargaining? So the first foremost thing is the affidavit should be submitted by the accused person. He should mark his voluntariness in filing the plea bargaining application, which means he has to show unequivocal consent. So what do you mean by this unequivocal consent? There is a difference between consent and unequivocal consent. So consent and unequivocal consent is that by way understanding the consequences and understanding the foreseeness of the consequences, and still he wants to accept it unequivocal. To get into know, still he is ready, then he is giving his consent as unequivocal consent. So the plea bargaining is, it is an agreement between a trio. It's a triangle. One side the prosecution, another side the defense counsel, and the another side is victim. So there must be a meeting between these three persons. There must be a negotiation between these three persons. The accused has come forward to provide some compensation to the victim. Victim has to accept that compensation. Once it is being settled, the prosecution has to submit the report to the presiding officer of the court from which the plea bargaining meeting has been made. And upon receiving the report, the court may award lesser punishment to the accused. So it is fulfilling both the remedies. One is the victim is getting the compensation. Another one is the accused is getting the minimum sentence. So that's what I told. The victim is deciding the justice, the remedy. What I'm going to get simply sending the person to prison. Anyhow, he is going to come out of bail. Anyhow, in appeal, he is going to come out of bail. So, in what was the justice made to him? So, this plea bargaining gives at least a limited space to the victim to decide whatever you want, you decide. If you want to accept the compensation, accept it. Or if you want to pressure more, you get it. And if it is accepted, this person will not going to be set at liberty simply because paying the compensation is not a ground to be acquittal. There is no acquittal in plea bargaining. There must be the punishment, but punishment is lesser, where the accused is also going to get the benefit out of it. So once the application or affidavit has been submitted, the court issue the notice to the public prosecutor or the complainant in the case, if it is a private complaint, to be appear on the fixed date. And the court has to ascertain the voluntariness of the accused person by way of conducting a proceeding in camera. Within the chamber of the judges, they have to ascertain whether the accused is really voluntarily to come for the plea bargaining. Only the prosecution, the accused and the court will be there, not even the other party. The other side party should have been present in the court. And upon satisfaction, okay, the court ascertained that the accused to come forward on his own without anybody's undue influence or any false promise or any coercion pretension, then the court has to fix a time for mutual satisfactory disposition. So it is a meeting, satisfactory disposition meeting. So this satisfactory disposition meeting is to decide the compensation and other expenses for the case of victim. So this is the where we really treat the victim on par with the accused. So far we discussed what are the rights of the accused person, arrested person, what is his right during a time of trial as a prisoner. But in this plea bargaining, we could find the term what the victim wants to be decided. If the court found that the application was filed involuntarily and accused has previously convicted, he should not be the habitual offender, and he may reject the application and send back the case for the regular trial. And the third one is guidelines for conducting the satisfactory disposition meeting. So disposition meeting is by the 3 members to decide the compensation and other cost. So the court issue notice to the again the PP or the complainant, the accused and the victim to participate in the meeting. And it imposes, section 265C imposes an obligation on the part of the court to ascertain that whether the meeting has been conducted according to the procedure. So whether all the 3 parties are involved fully in the dispository meeting, whether the victim has spoken out, whether the victim actually accepted the compensation, whether the accused accepted to give the compensation, all these things should be ascertained by the court. And accused alone is permitted to participate in the meeting with his pleader, with his counsel. Because for the victim, prosecutor will be there. And 265D is a report of the this meeting, disposition meeting. Once the disposition meeting is over, either the sessions court or the district court or the magistrate court where the plea bargaining petition has been filed, prepare a report. And if the meeting has not worked out because either the victim is asking for more compensation or the accused is asking for lesser punishment, if it is not worked out, then it will be sent for the regular trial. So, but if it is accepted, the court has to prepare the report. So, 265D is in continuation of E. So, once it is been accepted, if the meeting is successfully conducted and the victim is accepted to receive the compensation, what will be the next procedure falls within this 265E. So it says that the court shall award the compensation to the victim, the compensation which is accepted by the accused person and accepted by the victim. So during this pre-disposition, the satisfactory disposition meeting, what was the offer and acceptance? Depending upon that, the compensation will be awarded to the victim. And the parties to the on the quantum of punishment or releasing of the accused on probation under section 360 of the CRPC. So both the parties will be heard about what may be party here in the sense the prosecution and the defense counsel. What may be the punishment that can be imposed to the accused person, or if it is a fit case to be released on probation under section 360, that can also be done. While punishing the accused, the court, its discretion, the accused either 1 or 1/4 of the minimum sentence. So the court may sanction either 1/4 or 1/2 of the minimum sentence. For example, if the minimum sentence is 2 years, either 6 months or 1 year can be awarded. It is a discretion of the concerned court to be awarded. So the entire proceeding should be conducted in the open court. The judgment should be read out in the open court, and it has to be signed by the presiding officer. And the most important thing is it is final. No appeal shall lie against this order under section 265G. This is equivalent to conviction on pleading guilty also. When there is a full trial, either it may be the trial of the warrant cases or summons cases, if the accused person pleaded guilty, the court will convict the person immediately. So there is no appeal when the conviction has been passed on pleading guilty. The same application is also availed here when the judgment has been passed based on the affidavit and the petition submitted by the accused for plea bargaining, and if the meeting has successfully conducted, and if any order has been passed, that is final. No appeal shall lie against it. But it is not an absolute one. There are some exception and conditional one. What it says is that it can be challenged under through writ petitions before the Supreme Court and High Court to challenge that the plea bargaining has not conducted according to the procedure laid down by law. And another one is the period already undergone by the accused to be set off against a sentence. It is a general thing under section 428 CRPC also gives a set off of already undergone sentence will be set off from the conviction period. If the set off period is equivalent to that of the conviction passed in the plea bargaining, it is equalized, then he will be released on, he will be set at liberty. And 265K is a protection given to the accused person. What it states is that anything which has been stated in the affidavit submitted by the accused person shall not be used for any other purpose. So it should not be treated as the self-incrimination. It is the protection under Article 20 Clause 3, where the statement or the affidavit submitted by the accused person by way of accepting his charge or the offences is only meant for this plea bargaining and not for any other purpose. And last one is, it is again stating that it shall not applicable against any of the provisions of Juvenile Justice Act, because it comes in the year 2015. Now we it has been amended after this Nirbhaya's incident. Now we have several amendments in the Juvenile Justice Act, introduction of this heinous crime, introduction of children court, all these things. So any cases or the plea bargaining shall not be applicable in the JJ Act also. So these are all some of the nuances or the applications of this plea bargaining. So instead of accepting or choosing or getting into the chapter as one of the procedure, please think from the perspective of victim. So it is going to be very, very much helpful for the victims, because we are giving some space to the victim to decide their compensation. Because compensation, and not simply the compensation, on the other hand, accused is also going to get the punishment, but not the maximum punishment, but the lesser punishment. So it is satisfying both the concept. One is victimology, another one is reformatory or rehabilitative theory of punishment. So please, if you are in the practice or if you are in the court practice, try to create more awareness regarding this plea bargaining and try to implement this plea bargaining more and more in your court practice. Please encourage your juniors to practice this plea bargaining, because unfortunately there was no any landmark judgments with respect to plea bargaining till now. Now it's open for the queries.
Yeah, I will just check it out. I don't suppose we have anything on the chat box. Yeah, I will just check as to whether we have on the Facebook.
Yes.
No. We will ask Vijayalakshmi ma'am.
Okay, sir. Okay, is there any case? That's what I told you. Mahapara. As of now, there was no any landmark judgments on plea bargaining in India, sir, because it may be the research. Please conduct a research. How many cases or how many petitions or affidavit has been filed so far in magistrate court or a sessions court or a district court with respect to plea bargaining? Or conduct a research whether the court itself are aware about the concept of plea bargaining to be practiced. It itself eye-opening to others.
Vijayalakshmi ma'am, your conclusions?
Thank you so much, Madam Vijayalakshmi. It was an excellent session. I have heard the session from you before, but it was definitely a refreshing one to hear today. And of course, as you told, this concept has to catch up. A lot of concepts like mediation, which has caught up now. I think plea bargaining will also find its place sooner, not later. It might, and we have to all work together. And we should thank Vikas for thinking on this topic. When I was speaking with him over phone, I told she has an interest on the subject, and she has delivered once I have listened to her. And we should thank Vikas for inviting Legal Eagles Ally to partner on this topic. And thank you so much. Even on a working day, so many people have connected on the Zoom and also on the live Facebook Live. I saw so many participants. And one good thing was none of the participants left because of your session. They got themselves attentive, and they were glued. Because sometimes on the live sessions, you will see people fluctuating. Today I should thank all the participants who have joined in. Thank you, Vikas, for bringing us to the platform. But for you, we down from South would not have got such a great connect to North. Now North and South is in one line. Thank you so much. Over to you, Vikas.
Yeah, thank you,
before that, that's what I want to tell you, sir, because as told by ma'am, it's a bridge between South and North now, because we were not such
we always learned way back from Ramayana that how the bridge was connected. So we have to take the nuances as to how the virtual bridges can be connected.
There is one question: why lawyers are against using plea bargaining? It was a wrong misunderstanding. It's a misunderstanding by the lawyers that they will lose the brief. Definitely not. If you encourage your clients to go for a plea bargaining, you can claim the fee by way of fixing the compensation also. It is one of the out of the way and giving the idea.
Oh, no, it's always, when mediation also came, it was always first, they say every concept has, first there is sluggishness, then normalcy, then it takes up. So we are just going into the takeoff for the flight mode. And once we are saying of the flight mode, taking cue from that, tomorrow's session would be a bird's eye view of Muslim law by Professor Vijay Parveswaran, Vice Principal of CMR Law School, Bengaluru. So do stay connected with us tomorrow at 4:30 p.m. And ma'am, as they say, if you are going through a process of learning something, and sharing people with this, so this is the bargain which we learn once you bring good speakers. And I believe that Vijayalakshmi ma'am would agree with this plea of mine, that we have, in this entire process of bargaining, we have learned that how the knowledge can be shared on the virtual platform. So everyone stay safe, stay blessed. And on behalf of all those participants who have been watching us live on the YouTube, Facebook, as well as we have started posting on the LinkedIn also, the link, and on this platform. As Vijayalakshmi ma'am told, that the participation was quite constant. They say once the participants are same, though I've repeated once the participation level is the same, it looks very good. Except for the ECG lines, once it goes straight, it is bad. Everyone stay safe.